And we are live. Hello, welcome to My Court Coach first live stream. This is a live Q&A for California family law topics. We are speaking with the illustrious, the wonderful Chris Von Tall, California family law lawyer extraordinaire. Chris, that's what you do, right? It's family law pretty much exclusively?
I do other things, but most of my practice has been and continues to be family law.
Yeah, thanks for being here. Really appreciate your help. Um, so this will be our first Q&A. We hope to do it frequently. We hope to do it often, and really just as long as it's needed. So I hope everyone enjoys this. Welcome also to those people who are not live streaming, not watching this live, but who are watching at a later time. What we're going to do today is we're going to look at some of the comments that have been posted to different videos on the YouTube channel, and Chris is going to go ahead and answer some of these for us. Some of these questions that have been added to specific videos. Remember that nothing that is said here is legal advice. We are not your lawyers. Chris is not your lawyer. We're not establishing attorney-client privilege or attorney-client relationship. This is just Chris's thoughts on what the law is, but it's not advice specific to your situation. We ask you to not share any kind of details or factual details about your situation. Certainly don't disclose any names of any individuals who are involved in your situation. Okay. Chris, are you excited?
Sure.
Excellent. Okay, so let's look at this one. I'm going to share a video that we have here on our channel, and let's see if I can find it. And you see it there. This is about the findings and order after hearing. And someone asked a question. They say, "Thank you for the video. The minute order is different than the form prepared by the other party. What do I do? I went to self-help and they told me I had to follow what the minute order says." Do you see that there, Chris?
Yeah, I see that.
And this is regarding family law form 340.
Yeah, the answer is it's going to depend on how your particular county handles it. Down in San Diego, the way we used to do it when we had court reporters, if there was a dispute on what was in the formal order, the court would require one or both of the parties to pay for a copy of the transcript and then submit their proposed orders to the judge along with a copy of the transcript, and as well as a cover letter saying what the difference is between the two proposed orders and why you think yours is right, usually citing a page and a line from the transcript to say this is what the court had previously ordered. Now that we don't routinely have court reporters in the courtroom in San Diego because of budgetary reasons, it's a lot harder. Basically, all you can do is prepare your version of the findings and order after the hearing, attach a copy of the minute order to it, as well as your cover letter that says, I think the other side is incorrect in your proposed order. Here's my proposed order, and here's why I think it's correct.
Okay, so they're to attach a cover letter. What will that look like? Maybe if you can turn up your volume a little bit, that might help. Is that just a Word document, or what would they attach? Should it be attached on a pleading paper, like the miscellaneous attachment, or any recommendations there?
I usually just use a regular cover letter. If it's not a pleading, I mean, I guess you could put it on a pleading paper too. But in San Diego, we used to have a local rule that said attach a cover letter to it. So that's just how I do it.
Okay. All right. So that just any kind of Word document that you would write up any letter in.
Right.
Yeah. Okay. Perfect. All right. Thank you. I think that's a great solution. It seems like the right way to go. Let's go to the next question. This one is about notice. So there's a form, MCO 40. This is the notice of change of address or other contact information. And someone asked the question, they said, I initially filed using defendant's last known address, but was able to locate and get him served at his new address. Would this form be filled out as well if the defendant was the party who moved?
So I'm assuming the person asking the question is the petitioner, and the other party that they want to fill out this form for would be the respondent. And generally speaking, you don't fill out this form for the other party. And in fact, generally speaking, if they don't file an answer to the lawsuit within 30 days or some reasonable period of time after that, you're supposed to file a default against them. And so you're not really required to fill out this kind of a form, but when you fill out your default paperwork on the notice of entry of judgment, it's going to have the other side's best known address that you have for them. And so that's how you would tell the court what their address is so they could send them a notice of entry of judgment.
Okay, so if you're filling out this form, it's really for your own address, not for the other party's address.
Correct.
And to give the court notice of the other party's address, what if you're not filing for default?
Well, it's the other side's obligation to let the court know their address. It's not yours. I mean, if you wanted to give a letter to the court saying, here's their address in case you need it, but for the most part, the court doesn't send notice to the other side unless they're participating in the lawsuit. Now, when the respondent files an answer to the family law case, they put their name and address on the top of every pleading. So the court should know that's where their address is.
Okay. All right, which they should do once they're served. If they're served at the new address and they got it, then they'll probably, hopefully, be responding then.
Right.
And then they'll give their new address themselves. In theory.
Correct.
Okay. The next question here. It relates to how to respond to a petition. You'll see it here in a second. So this is a video regarding the form FL 220, how to respond to a petition to determine parental relationship. And the question says, what if questions 6A, 6B, and C do not apply to you? Can you leave it blank? And this is specific to the family law form FL 220 and the questions on those forms. Let's see, 6A, 6B, 6C.
Right. I'm looking at the form, and it's a real easy one, actually. You only check those boxes if they're true. If they're not true, you leave them alone.
You just leave it blank?
Yep.
Okay. Simple enough. And we have two more questions here. This question is this is regarding the form FL 170, the declaration for default or uncontested divorce in California Family Court. And the question is, well, there's a few questions actually on this form. Do both petitioner and respondent need to sign this form? This person says, my divorce case was contested at first, but then it changed to uncontested as we both agreed to get it over with. What kind of insight? And then someone responded saying, do you have to wait 30 days in California to file the MSA if all issues agreed upon? Uncontested and spouse not filing response due to more unnecessary fees. So perhaps you can answer that first question.
Yeah, those two questions don't really seem related.
Right.
But the first one is whoever is submitting the proposed judgment is going to fill out this form. Only one party has to fill it out. And generally, if it's now an uncontested, but it was contested, that usually means both parties have appeared in the action. Somebody filed a petition, the other party filed a response. And so the only way you're going to be able to default it at this point or go forward as uncontested is by submitting some kind of a marital settlement agreement or other property settlement agreement. And so when you submit that, you attach this to the front of that agreement as well as the rest of the judgment package. And in the judgment package, you'd have the judgment cover sheet, you'd have the notice of entry of judgment, and there's a few other things that are in the packet that have to be filled out in addition to this one, depending on whether or not they've already been filled out. But yeah, so only one party has to sign this particular form.
Okay.
And again, because I'm spending most of my time in San Diego at the court website has a very helpful form packet for entry of judgment. And this form, as well as all the other ones you would need, would be in that packet. So you could download them as one big packet to make sure you're not missing something.
Okay. What about this other question? You're right, they're not related. The second question is not a response to the first or a reply to the first. It says, do you have to wait 30 days in California to file the MSA if all issues are agreed upon?
I have no idea where that concept of waiting 30 days came from. No, you don't have to wait. If the parties have an agreement, they can file an MSA. Now, the next sentence in that question is uncontested and spouse not filing response due to unnecessary fees. If you're filing a marital settlement agreement, it's going to require that both parties pay their first paper fee, which is currently about $435. So if the respondent doesn't want to pay their fees, then you have to go with the more traditional default, and it's usually not a good idea. It's usually a good idea if the parties have an agreement to have a written marital settlement agreement and both parties pay their fees so that the judgment that gets entered is the judgment that people are expecting. You don't want to find out 2 years from now that somebody entered or that the petitioner entered in a judgment that was not consistent with what you thought it was going to be.
So what you say, is it impossible to have an MSA where only one party has appeared in the case, has filed something?
Yes, you can have an MSA when you do that, but they're going to require the full filing fee from both sides. And so you might as well do your responsive paperwork and do the MSA.
Okay, otherwise it's a default. You can do both, but you can't do default and MSA. Well, not at the same time, is that right?
I mean, if you're doing a default, you're not doing an MSA. If you're doing an MSA, you would be doing an uncontested divorce. They're similar, but it's just a different word.
Okay. Okay, thank you. And let's go to our last video with a question.
And there was on that particular, there was a third person that had a question.
Oh, I missed it. Okay, let's see if I can find it.
So it's talking about the form FL 170 again, and it says, if I fill out 4A, do I still need to fill out 5 regarding the declaration of disclosure? And yes. So depending on how you fill out section 4, if you say this is a default without agreement, then under section 5, you would check the box B that says this matter is proceeding by default.
Okay.
Or whichever one of these applies, either B or C. But if you're, if under 4 you're saying you're doing a default with an agreement, or you have an uncontested agreement with a marital settlement agreement, then you would check box 5A.
Okay, got it. And the last video with the question here is about the form FL 985, the proof of service by posting or publication in California Family Court. The question is, this person says, I received this form by mail, but it says in red at the top, copy, with a stamp, copy. What does this mean? and what do I have to do next?
I don't know. It doesn't make sense for them to have a blank one that has the word copy on it. So maybe it's been filled in.
It must have been filled in.
Well, so stepping back, I guess, this particular form is not used very often because it's very rare that the court is going to allow you to serve somebody by posting it. 99% of the cases, the court is going to require that you serve the other side with the paperwork personally. If that's not available for some reason, if the person's completely missing, you would wind up doing a summons by publication, in which case it would get published in a newspaper, which costs money. The only time you would be allowed to do service by posting, and that would be you put it on the wall down in the family law business office, and it gets left up there for a certain amount of time. The only time that you can do that is when the respondent is completely missing and when the petitioner has a fee waiver so that they don't have to incur the cost of publication in a newspaper or a magazine. And so the petitioner would then have the burden of filling out this piece of paper, which would say, here's what I served, here's what I posted on the wall, and that's what this form is for.
I wonder
honestly, I've never filled one out.
Yeah, I think I've done publication by posting once.
I did it in the past when I was working at the facilitator's office, but this form didn't exist that long ago.
I wonder if this person, not the person who commented on the video, but whoever the other party was, I wonder if they didn't know this person's address and so somehow got this ability to, well, who knows? We don't know if they actually got permission to serve by posting or not. But maybe they thought, I don't have this person's address. And then afterwards, they discovered this post to this commenter's address and then said, hey, I'll just mail it to them.
Right, but at any time that you find the other person's address, you still have an obligation to personally serve them. Other than that, I mean, you're committing fraud upon the court because when the judge goes to enter the judgment in this case, if all of a sudden you're able to find this person, you're required to invite them to the lawsuit.
So this individual who got, assuming this document is actually for them, and he got this in the mail, his obligation, is he obligated to notify the court, hey, this is the wrong, or notify the other party, you still have to serve me. Can he just ignore it? Or even if he can, is that wise or unwise?
If I was the responding party and I got anything suggesting that my wife or the mother of my child had filed some kind of an action in family court, I would get down to that courthouse as soon as possible to find out what had been filed. It's never a good idea to try and dodge service. The court could decide to go ahead and enter a judgment without you being part of it, and it becomes a huge mess to clean up. If you find out about the lawsuit, get down there, get a copy of it, and then figure out how you want to respond to it from there.
Right, and then maybe the other party will have to sort of start all over and get you personally served, like you had commented.
Well, if it were me, I would file an answer, and then they would have to serve me with all paperwork from that point going forward. I would never allow the other side to decide issues regarding custody and visitation of my child without my involvement and without my being given notice of a court hearing. You know, that's not to say that me and my child's mother couldn't come up with some kind of agreement. We certainly could, but I wouldn't want to ignore the fact that we've been summoned to go to family court services to talk to the social worker, and then as well later go to the courtroom to talk to the judge about what's going on in the case.
Right.
Now, if people come up with an agreement and they want to have a written stipulation, okay, then you just want to make sure that stipulation gets filed.
Right. Yeah, and that goes back to that other commenter who had an uncontested, they agreed on everything. And, yeah. Okay, excellent. That's all the comments and questions that we have for today. Really appreciate your help. Chris, there's a lot of people who are going to be benefiting from this, and specifically, of course, those commenters. Very kind of you to grant us your time. And if people want to talk to you and get more help from you, you practice in Southern California. Is that right?
Yep.
Okay, and they can Google you. There's your name right there, Christopher Funtal.
Right. And you can look up any attorney at calbar.org, and it will give you their name, address, and phone number that they have listed with the state bar, and I'll make sure mine is current.
Okay, beautiful. Excellent. Thank you so much for joining us at My Court Coach. And those of you who are watching, subscribe, like this post, subscribe to the channel. We're going to have more of these coming up, and you will want to be notified. Go ahead and comment on any videos that you have. Ask your questions, and again, in a future episode, in a future week, you'll be able to respond to those comments here in a live Q&A. Thanks so much, and we're signing off.